Good morning, or afternoon. It's still morning, right? Everybody can hear me okay? Wow, this is like an echo chamber. Okay, so I'm the person you don't want to have to hire, and I'm gonna try not to be a total downer, but I think it's important for people to sort of understand how the laws work, where they come from, what is it that's happening out there, how can we kind of try to figure that out, and ultimately, what can we do to improve the shit show that is currently drug laws in this country? I don't have a great answer to that, but I have a few ideas. So I describe my job in two ways. One of my descriptions that's kind of the sad one is that I'm a professional unfucker. I try and unfuck things up. I traffic in human misery, and I sometimes get to stick it to the man. So that's what I try to do. That's my favorite part. The days I get to actually stick it to the man are like, yes! But unfortunately, criminal defense attorneys often are faced with some kind of narrow options that we have. But before we get to all that, I'd like to talk about just generally, let's talk about what is the law around psychedelics. Here's my disclaimer. No legal advice here. I'm actually only licensed in Washington State, so this is just for general educational purposes, and if you need specific advice, please contact someone in your area who's licensed. Okay, no great news on the legal front, just things to know and ways to work on creating a brighter future. So, sources of law. Ooh, this is a little dark. I think before I went to law school, I didn't really get, okay, yeah, law is this thing, you know, and we kind of know some limited laws, but after you go to law school, you have this horrifying sort of realization that law comes from all these different places, and it interacts in a lot of kooky ways, and sometimes it's contradictory. And so advising on a thing that might be a legal issue can get really complicated because we're looking at a bunch of layers. So really the sources of law we're dealing with when it comes to psychedelics, I think are, you know, the biggest kind of sources of law that we think of are constitutions. We have the United States Constitution. Well, each state has a constitution as well. And that's a pretty interesting thing, I think, in terms of this topic. We also have statutes. We have federal statutes. We have state statutes. We have administrative rules. And then we go down to the levels of municipalities and counties, and they have their own sets of rules. They have their ordinances. And oftentimes ordinances contain criminal laws. They contain criminal consequences for breaking certain laws. So even though you may not get busted by getting your stomach pumped and them finding a little peyote button, you might get busted for wandering around and being weird in the park in the middle of the night if you're in Vancouver, maybe. So you have to kind of know, where am I and what are the things that can put me at risk and how can I sort of avoid these risks if at all possible? Jurisprudence, this is the weirdest branch of the law. The courts, that's where I live all the time. And we have these things called judges. And most of them used to be lawyers, and then they try to decide what the legislature meant when they wrote all this stuff that is supposed to be applied to us. So that's a crazy thing, and I would encourage you all to really think and study when you're gonna get out that little ballot, and you've got judges on that ballot. Not all districts or not all areas have elected judges, but when you do have elected judges, these people are doing a whole lot to shape how the law is applied to individuals in your community. So think about that. Courts are, we think about a courthouse, but really what courts are is dudes in robes and girls in robes, more dudes than girls, but I'll call them all dudes, okay? They have robes, they have agendas, and a lot of them come from a really conservative place. So if we scrutinize the people that we're putting in those positions of power, as we all know on the national level right now, we want to think about that. Levels of regulation. We talked about this. We'll probably make these outlines available later, so I'm not going to belabor going into the little details here. This is a little bit hard to see, but we have federal statutes, state laws, administrative code. We have counties and municipalities, ordinances, as I had mentioned. And then the courts and tribunals have a lot of different levels as well. So we have several levels of federal courts. We have the federal district courts, which is the trial level. Above that, we have the circuits, the federal circuits. So we have the 1st through the 9th Circuit and the 10th Circuit, the courts of appeals. And then we have the Supreme Court. And then we have state courts, and most states have something similar in terms of that structure. We have trial courts, and then above that we have appellate courts, and we have a Supreme Court for the state. The state courts interpret state laws and apply state laws. The federal courts interpret and apply federal laws. Sometimes there's overlap, but that's it's interesting how it works, and we'll get to that. The Federal Controlled Substances Act. This is where we find all of this lovely information that tells us that the feds really don't like hallucinogenic substances. They're considered drugs. And according to the feds, drugs are bad and they're dangerous and all kinds of stuff like that. There's a recognition of danger involved in manufacture, distribution, and use of certain psychotropic substances. And then we have international treaties as well. International treaties, all of this stuff is usually kind of aimed towards defining criminal acts and regulating things that they think are dangerous. So we have sort of two facets of the law. We have the regulation end, and we have the criminality part, where there's all these things that people can do to get them into trouble. When we look, for example, at the offenses and the penalties section, this is just a few selections from there. There's federal penalties for simple possession. There's civil penalties for possession of small amounts of controlled substances, continuing criminal enterprises, criminal forfeitures. That's a really ugly and scary area of law where, I have defended people who were accused of being drug dealers, and then they decide that they're going to take a bunch of their property, which can include real property, it can include cars, it can include things like that. And you don't even have to be convicted. You just have to be accused, and somebody has to think it's more likely than not that you were doing this awful, awful thing. Then maintaining drug-involved premises, I just kind of wanted to point that out. There's some really creepy laws on the books. If you're maintaining a drug-involved premise, the way that that's defined is, you're either managing or controlling a place, either permanently or temporarily, or as an owner or any of those other things, knowingly and intentionally renting it for the purpose of unlawfully manufacturing, storing, distributing, or using a controlled substance. This is a really, really crappy law because it says, not only do we not want you to use, but if you have this groovy place that you like to have people sort of gather and do this kind of cool thing on a regular basis, and you're all gonna open your minds and get a religious experience, well, if that happens to be a Schedule I controlled substance and the feds figure it out, they could actually come and they could impose up to 20 years in prison for maintaining a sort of a drug place. That is a big downer. The likelihood. So then we get to, well, what is the likelihood of that? I hate that question. I have people who call me up and they're like, well, this is what I'm doing, and am I gonna get caught? And I'm like, well, okay. Let's start thinking about all the things you're doing. And oh, by the way, I can't advise you on how to violate the law. That's illegal for me to do. So let's just talk about, do you know who you're hanging out with? Do you know who you're talking to on the phone? And kind of what's going on. So I'm not going to get real deep into that right now, but I'll get into that a little bit more. If you want to know where the federal schedules are, they're here. If you're like, wow, this is a really new drug that somebody just said is a new isomer. It's a chemical that is kind of like marijuana, but it's not. Look at the schedules. Schedules often include isomers. Sometimes they are specific types of isomers, and sometimes they're more general in terms of the types of isomers of the particular controlled substance that you're talking about. But if you don't know if something is actually a drug that's on a schedule, they're all out there. And if you can figure out the chemical compound and what it actually is called, then you can probably find that if it's listed. But there's more than one level of the schedule, so there's several schedules on the federal level. Schedule 1 is where most of the hallucinogens are, so I haven't really talked about the other schedules. I just needed a break from all of this darkness. So these are where most of the psychedelics are listed in Schedule 1C at the federal level. If you can't read that, don't worry about it. You can find it on the internet. I just needed to not have everything be so stark. I know, it's a bummer. But like Saul, not quite like Saul, I don't make these laws. It's your legislators that make these laws that they want to apply. So I do my best to try and help people once they get sideways. The Federal Controlled Substances Act, this is where it is. Law, cornell.edu is a great source. It's free on the internet, and you can look through a lot of statutes in their language. The bad part is that doesn't tell you how the courts interpret those statutes necessarily, so that can get pretty complicated, and that's where lawyers come in sometimes. Each state has their own schedule system. Most of the states do, and most of them mirror substantially the federal schedules, but not all states have all of the same substances on their schedules. So that gets kind of interesting as far as, well, if we look at the federal schedules and we go, okay, what is it that I can't do? Well, there's not much that you actually can do. Most things you can't do. But the question then is, how is this law going to be applied, or how is this going to get enforced? And so what is the likelihood of me interacting with federal agents? You know, that's an interesting question. It's a weird question. I've certainly seen a number of federal cases in my time where people were like, oh, federal agents, how did they get involved with this? And you know, the FBI is, these dudes are like in your community, and they're wandering around and trying to look hip and seeing if they can cause trouble. So the feds are out there, but where are the feds and what are they doing? I don't know what the feds are doing right now. You don't know what the feds are doing right now. We just have to sort of kind of make some assumptions. So Oregon has some things that are prohibited. Interestingly, Oregon has some things that the feds don't like that Oregon's pretty enthusiastic about right now. We'll talk about that later. 21 USC is where they kind of tell you what the intentions of Congress was. And this sounds kind of cool. I was like, well, okay, they think that psychotropic substances should be available for medical and scientific purposes. They don't want to unduly restrict them, but they don't want to interfere with bona fide research activities. It sounds kind of groovy, but courts interpret the laws collectively. So Congress and your state legislatures sometimes make these big sort of pronouncements that make it sound like they have these great intentions and these are going to be great laws for us, but then they get really weird. And so you have all of these other things that come in. And for example, marijuana-related decisions right now, it's kind of, I think that's probably the best go-to place for us to figure out what will the courts do with psychedelics that are being used in the therapeutic context or potentially in the religious context, because that was a big one, and marijuana has gone through the courts on many levels. When we look at this combination of laws, the sort of question of which law rules, there's this issue of federal preemption. The feds are kind of like, well, we can preempt state law by an explicit mandate, or we can just do it by indicating an intent to occupy that particular field of regulation. What? Okay. That means in your state, they might be like, yeah, this is so cool. Marijuana is legal now. And guess what? We're about to legalize psilocybin. And we think mescaline's cool too. And you know, let's just start legalizing everything. And then the feds can be like, that's cool. Well, let's see how cool it is. Because they're going to come in. Federal preemption means that they can kind of say, we don't care if it's legal in your state. We can still regulate this, and we can do it from a federal level, and we can come in and we can tell you what to do. So there's a lot of levels that might take place. It might take place at the level of the DEA. The DEA, for example, handles licenses for physicians to be able to administer drugs or controlled substances under those schedules. So the DEA might want to have something to do with your license if you are in violation of a federal law. Even if your state is saying it's all groovy, the feds have this whole other world that we sometimes have to deal with. Now, there are times where the laws interact, they kind of react, and sometimes it's just the symbiotic thing. So in Oregon right now, one of the things that really scares me to death is someone I really love is like doing this really cool CBD business. And I'm like, okay, the lawyer in me is scared because I don't know what the federal world is going to look like, in a couple years, and all these thriving businesses and this wonderful sort of renaissance that we're having. The feds aren't cool with it. They're just like, well, we're just not dealing with it right now. And at any point, they can change their mind and decide, hey, yeah, we're not down with this. Now, whether that's going to spark a total revolution, that might be why they're not trying to do that. But the feds technically can come in and bust all of the pot shops, and they can take their land, and they can take their money, and they can take their houses and their cars and all that great stuff. That's not very peaceful coexistence. That's kind of like, well, we're trying to do this here, but the feds are like, well, yeah, we might let you. So be aware that there's all these levels that this is going on, and ultimately, you're in any given jurisdiction, you're going to be subject to a whole bunch of potential things and kind of agencies that might want to come down. At the end, it's really about how the courts and judges interpret all of those laws too. So they have a tremendous amount of power. Religious freedom. So entheogens, that's what we're here talking about today. Doesn't that seem to fit like really squarely within what is religious freedom? Shouldn't we be free to explore our religion? The Supreme Court hasn't done a real specific job of defining religion. They understand that religion is kind of tough to figure out exactly what that means. They recognize that it can be monotheistic, it can be multi-theistic, it can be animist, it can involve, plants, it can involve just about anything. I think there are some cases at the Supreme Court level where they've tried to kind of define what is religion, but they don't do much with it. They're not very good at defining it. But they're really good at coming up with weird ways to sort of justify the ends that they want. Even when we think we have this really cool set of rights, we have rights, right? We have a religious freedom clause. But this is really hard to read, but I just thought it looked cool. So the Controlled Substances Act, according to the feds, doesn't violate a marijuana user's right to privacy since smoking marijuana doesn't qualify as a fundamental right. Okay, so no protection there from the federal Constitution, and medical marijuana caregivers didn't have a claim arising from a raid of federal authorities. Even if it was permitted under Montana law, it was still illegal under the Controlled Substances Act and subject to prosecution under the Supremacy Clause. That's what we were talking about, where the feds can kind of come in. So there was no violation of the US constitutional amendments because the feds can kind of walk in. This is a bummer case, and it came right out of Oregon. In Oregon, what happened was there were these two individuals who were using peyote in a ceremonial context, and they got fired from their job that was a state job because of that peyote use. And so they sued because they said, hey, that's an infringement on our religious freedom. And the Supreme Court basically just did this big kind of, sorry, but we don't see it that way. And they said that the wonderful Justice Scalia, who wrote for the majority, he decided that the court has never held that an individual's religious beliefs excuse him from compliance with an otherwise valid law prohibiting a conduct that government is free to regulate. So they basically kind of did this weird balancing test And they said, you know, if it's a law of general applicability and we're kind of regulating this conduct that we find harmful, generally speaking, then it's not a law that's specifically directed at your religion. And so tough beans, you don't get the protection of the US Constitution for your religious beliefs when it involves sacraments that are Schedule I substances. So, Congress, law to the rescue, kind of. The Religious Freedom Restoration Act. After this happened, Congress went, oh no, we don't want the law, you know, kind of running all over our religious rights, so let's do something. So the Religious Freedom Restoration Act, Congress basically set up a pretty specific test as far as what the government, when the government can actually run roughshod over your religious freedom, and it's a pretty protective test. It says they don't get to just come in and kind of do whatever they want. They can't just use this kind of excuse. Well, that sounds great. It seems like everything's going to be groovy, but then Gonzalez. And so this was one where it actually worked out pretty well, where in New Mexico, there was a church, and I speak Spanish and a little French, but I'm really bad at pronouncing Portuguese. So Gonzalez versus O Centro Espírito Beneficente União do Vegetal, I guess that's how you say it. The feds basically got shut down by the Supreme Court, and they said, no, these guys can import ayahuasca. That's actually covered under the RFRA. It's okay for them to do that. So there was a big cheer that came up. But then, why doesn't that make it all groovy for everybody? Well, then the Supreme Court in City of Bern versus Flores decided that the RFRA exceeded the powers of Congress. And they said that although the act was constitutional as far as federal actions, it could not be applied to the states. So that means that if the state didn't like the thing that you were doing and it was illegal in that state, the RFRA doesn't protect you. You don't have the religious freedom under either the RFRA or, according to Scalia, under the US Constitution. Those won't keep you safe. So, state constitutions and statutes. Well, the federal constitution doesn't really get us there. Some state constitutions and statutes might bring some relief. Doesn't protect us necessarily from federal actions, but an entheogen, if that's really what's happening, is it really can be, and I think it's a fascinating time that we're in right now as far as a more kind of socially acceptable or I guess institutionalized understanding that religion and mental health are an integrated thing. So I think in the practice of mental health therapy, when we are integrating religion in that and we understand religion as an inextricable component of mental health, I think it makes it really hard to extricate the right to freedom of religion from that mental health process. So that's how I like to think of it. I'm going to argue that soon. I'm probably going to fail miserably in the trial court, and then we'll see what the higher courts think. But each state has its own protections. So after the Supreme Court said, we're not applying RFRA to the states, a bunch of states went, we like RFRA. Well, I don't think the states really liked RFRA. There was some of the whole peyote thing going on with the states in liking RFRA, but some of the liking RFRA thing had more to do with the Bible Belt and, employers not wanting to have to, provide health insurance that covered birth control or whatever. So there's that in a lot of these RFRA statutes. Each state that has a RFRA statute has kind of its own version. There are some that are a little more generic and that seem pretty ample in terms of covering religious freedoms. That's really nice if you're in a state that has RFRA coverage. But then you also want to remember, well, what kind of a state is this and what do the courts look like? What do those robes look like? Who are the people in the robes? So if I bring a RFRA claim in this particular state, if I go, yeah, this is a groovy state, they can't bust me for using psilocybin here, I'm going to set up a church. Well, maybe. But remember that you've got judges, and I don't know what those judges are going to do with that, but you may have some pretty strong defenses. If a local prosecutor gets upset enough, he might call the feds, though, which is pretty unhappy. I think the feds, under the federal Constitution, I haven't actually seen a case where somebody made a claim of religious freedom as a state constitutional guarantee, and then the feds came in and tried to muck it up. I don't know. I can't tell you the answer to that. But it's interesting. I think it's also kind of weird and interesting that, our liberal Pacific paradise, Washington, Oregon, and California, didn't do anything as far as passing any RFRA laws here. So we don't have RFRA statutes out here in the beautiful Pacific Northwest to protect our religious right to use hallucinogenic substances. The RFRA is not something that we can lean on as a basis of affirmative rights to let us do this thing that a lot of people are finding super helpful. The RFRA is a weird sort of package deal. So if you're thinking about looking into how do we get Oregon to have a RFRA? How do we sort of get more hip to this out here? Remember that RFRA also has to do with what kind of a church can I construct downtown? And I don't know, maybe the RFRA would be like, hey, if you're the Church of the Aryan Nation, you can construct a swastika-shaped church downtown and the government can't make you take it down. I don't know, I'm just making that up. But the RFRA is a really interesting kind of weird instrument in terms of what all it protects. So yes, I think these kinds of statutes can certainly protect cool people like us who are out on the fringe and we want to do great things that affirm humanity and that help us evolve as individuals and evolve spiritually. But on the other end, the RFRA can also do some kind of crazy things in terms of being able to allow particular religious views to do a lot of things that otherwise the government would say, nah, we're not gonna let you do. So I think Oregon and Washington in particular are a little heavy-handed in terms of their approach to regulating and kind of administrating. We're pretty heavy regulatory states out here. But, I don't know as far as what will happen with the RFRA. So there's some state and federal kind of constitutional tensions that you can look at. It's interesting, I think this is a Wyoming case where it just indicates generally that in Wyoming, they need to look at the state constitution first, and then they can look at the federal constitution. Part of that is because the state courts are going to be the ultimate authority in applying state laws. So if there's a protection or a right to be had in that state, and the state court says, yep, we're gonna affirm this right under our state constitution, the Supreme Court doesn't get to mess with it, okay? So state constitutional protections, Washington has this really terrible test that we have to do every time that we wanna talk about how the state constitution is more protective. We have to go through all these factors like the textual language and the difference in the text and the constitutional history and pre-existing state law and structural differences and a bunch of crazy stuff like that. But we do have a Washington Constitution that some of its provisions, the language is significantly different from the federal Constitution, which is actually more protective. Article 1, Section 7 in Washington, for example, which covers search and seizure, is more protective. And so the kind of squishy search and seizure laws that you get out of the federal courts and out of the Supreme Court and these kind of balancing tests, we don't go for those in Washington. We say, no, you need a warrant unless you actually have an exception. And then we have listed exceptions. It gets squishy sometimes, but we do have some things that are certainly more protective. This is another example. New Hampshire is another one. Washington's religious freedom, Article 1, Section 7, is significantly more ample than the federal Constitution. I'm trying to work with that right now in a case, but it is a mess. We also had a Washington appellate court, which was not the Washington Supreme Court. A Washington appellate court decided that they were basically going to use the federal balancing test on religious freedom in the context of intoxicating substances. So the marijuana case, the Rastafarian guy, Washington basically said, nah, it's Schedule I. There's a compelling government interest, and we're just regulating. It's a law of general applicability. We're just regulating this substance. It's dangerous. So sorry, your religious rights don't hold a candle to that government interest. But then there's this older case that really has much stronger language that Division II ignored. So I'm geeking out on that right now, and I won't go into it too deeply. I don't know. I want to make those arguments, but ultimately I don't know what the appellate courts and the Supreme Court I don't know if they'll care. I don't know if they'll just think, these, kooky hippies, they just want to take drugs. I don't know. Free speech. Okay, this might be a little bit of a light in the tunnel. There is this thing called free speech, and we have gotten some good decisions out of the courts where they said there was a group of physicians and scientists and patients who challenged the constitutionality of a federal policy regarding the federal authority to prosecute people involved in medicinal marijuana use and sales. And they basically said that, you know what, you can discuss the benefits and risks without fear of prosecution. Prescribe. Is this cutting out?
When you get close to the microphone, it picks up.
Okay, I'll try not to wander around so much. Is that better?
Yes.
Okay, so you can't prescribe under federal law, but it is okay to discuss the benefits and risks of marijuana with your patients. And by analogy, because we don't have cases on psilocybin by and large, the cases on psilocybin are like, was it psilocybin or was it not psilocybin? We haven't gone here with hallucinogens much. So we have to kind of do these comparisons with other cases. So I think marijuana is going to be fairly comparable in terms of therapeutic use. And it looks to me like, you can discuss these things with your patients openly. And you can certainly, now at some point the feds wanted to say that you couldn't just discuss the benefits without discussing the risks. I don't know, that's kind of crazy. I think as doctors and medical professionals and therapists, you're always going to have a mind towards discussing risks and benefits, so I'm not sure who is going to just be like, yeah, do this, and there aren't any risks. So, you can talk. You can talk. I love this. It's not legal advice, but it's cool. Don't write anything down if you can phone. If you don't phone, if you can talk. Don't talk if you can whisper, and don't whisper if you can just smile, and don't smile if you can nod, and don't nod if you can wink. You can say a lot with a wink. Hey, this weekend. I really like those conversations because they're not in writing and they're not tape recorded, and then they can't be used against you. Regulating professions. I'm not going to delve too deeply into this, but I'll try and make this available for everyone. Each state regulates professional conduct, and they tell you what's unprofessional conduct, and they tell you what you can do and what you can't do. If you're a licensed professional, you probably have this whole other code that you have to deal with. It's not just the state and federal criminal laws, but it's what can you do as a professional that will get you in trouble, and what do you have to do so that you won't get in trouble. There are affirmative, and there are there are affirmative acts that you have to perform, and then there's all these negatives, these things that you can't do. I'm not going to try to tell you what all those are for your profession and your state, but it's important to be aware of that. The rat rule. So Oregon is kind of a rat rule state. Washington is not so much a rat rule. That's actually one of the reasons that I wanted to be licensed in Washington, I must say. I've always hated being a rat. And Oregon says if you're a lawyer and you know one of your lawyer friends screwed up big time, you got to rat them out. And I don't want to rat anybody out, so I was like, nah, Washington's cooler. So unfortunately, there are some parallels in terms of other professions and rat rules. So, I don't know. Remember the wink, I guess. What you don't know about, you don't have to report if you're in one of those states where you have a lot of nasty rat rules that you have to report people. Washington, not so much. Washington, it's only if a person is really impaired in their ability to provide services, or if they're actually doing something that's put patients in danger. Things to be aware of as professionals and kind of figure out how to navigate. Washington Standards of Professional Conduct. I just put some of these things in there for reference, but I needed a break. Breathe. Feel the universe smiling. Okay. Oh, I need some more smiles from the universe. Okay. Professional ethical responsibilities. How does the law interpret your professional duties regarding scheduling substances? It's super complicated. That's the answer. I can't just sort of give you a big kind of presentation that says this is exactly what you all have to do, especially not in Oregon since I'm not licensed here. But there are, you know, some interesting things, and there was a class action, Sterner versus United States. I think that was in the Southern District of California. That's where everybody agreed the DEA rules didn't allow a physician to prescribe, but the DEA, the government tried to get a physician's license revoked for recommending marijuana to a patient. That didn't work out. Remember that whole free speech thing. There's a few other cases that kind of look at this stuff and recommending medical marijuana. Generally, there's a thing where talking about it's okay, but prescribing is a whole nother thing. And remember the DEA, it's another one of those regulating agencies. And so that's one of those that you probably have to watch out for if you hold a DEA license. So a few legal with my clients are people who are just, you know, randomly running around. Sorry, I'm doing it again. See, I like to wander. Most of my clients are people who just are randomly running around and interacting with drugs, not so much prescribing them, sometimes certainly trafficking in them. And I wanted to give you a notion of what do I do when I get these cases? Well, I'm looking at a bunch of things, trying to figure out, do I have some kind of legal defense? Technicality is a big word. It's kind of a fun word. Sometimes it's a technicality. Technicality is usually stuff where we're talking about search and seizure. We're talking about what can the government get and how can they get it? How is it legal to get that? Hey, that hippie van looks like it's full of drugs. I'm gonna stop that dude and search it. That's not a legal search. I would love it if I could get that case, but what the cop will do is he'll say, well, he failed to signal, and I pulled him over, and then when I pulled him over, he was reaching into his waistband. I had him step outside the car for officer safety. So, you know, search and seizure is like, yes, sometimes we have cops that are just really like, I had this one time who was great. I had a black client who was coming out of a club, and the cop was like, I'm gonna stick my hands in his pocket. I know he's got something. And he did, you know, just kind of walk up and be like, hey, and he just kind of stuck his hands in his pocket. At the time, marijuana was illegal. And I was like, God, I bet he might figure this out. And what I did was I tricked the cop by focusing on race and getting him all tripped out, and I stared into his eyes, and I was like, my client was black, and you're white. And he was like, and then we got through that whole part, and I was like, so what'd you do next? And then he's like, well, I stuck my hands in his, okay, how'd you do that? When what'd you do? And so it was really great. I kind of baited him, and then he didn't know how he screwed up. You know, sometimes I get to do fun, magical things like that, but a lot of times it's not that magical, and, you know, we're trying to do a lot of sort of mitigation, and we're trying damage control. When we're defending a case, we have to traffic in truth. Like, we have these rules that say that we can't put on a false defense. So, like, a really fun defense is the Saudi defense. We call it the Saudi defense. Some other dude did it. And if I get a legit Saudi defense, that's super fun. I had a legit Saudi defense on a mushroom case one time. But how that, you know, ended up, it was in a really crappy county. It ended up coming from a felony down to a misdemeanor. And so, you know, for my client who was he was retired from a high level in government, didn't do it. It was one of these stupid, you know, rangers are overzealous and basically trying to trap anybody who talks to a hippie. You know, it was a result that was damage control. And although we may well have won, that was a great case because I was actually going to put on a character witness who was a retired Army chaplain and priest who showed the prosecutor a picture of him and the Pope. And the prosecutor was Catholic and just about fell over, and he apologized for prosecuting my client. But then his boss wouldn't let him drop the case. His boss said, no, we'll do a misdemeanor. So, you know, there are great defenses. A lot of times great defenses end up with, you know, compromises that end up kind of protecting people because it's really scary to go to trial and face a felony when maybe you could just walk away with a misdemeanor that you can get to go off your record in a fairly short period of time. So medical necessity. That's probably why I'm here today. I'm trying this kooky thing in Washington. Washington is a state where medical necessity still exists. Nobody's ever tried this defense before. I have a psilocybin case right now. I'm pretty excited. Have some cool experts coming out to testify. And I'm saying, well, Your Honor, there just really isn't any other way that's equally effective or that's good treatment. And my client was possessing psilocybin because of a medical necessity. Done tons of briefing on it. It's going to be really interesting. The judge at least thinks it's interesting. So that's exciting, because the judge could be like, what the, what are you doing in my courtroom again, Ms. Dalton? That's one of them. But he's kind of like, oh, I learned something new from you every time you're in my courtroom. And that makes me feel pretty happy, even though he may well shoot us down and it may be a case for the courts of appeals. Having a case for the courts of appeals is not a wonderful thing as an individual. As a lawyer, it's like, ha, 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 this is the one, it's cool. But for the individuals, it sucks because you get to the Court of Appeals by losing. So we don't want to lose and get to the Court of Appeals. We don't know what's going to happen. Medical necessity might fly in some places, other places not so much. There are, certainly in California, they've said medical necessity was not a defense to a federal prohibition of marijuana use. In Washington, it is available, the common law. I think in Oregon, not so much. There's some more stuff on medical necessity. If you want to look at it, I'm going to kind of click through it because it's black and white and super boring. And I don't have a lot of time. So, is there any legal use of psychedelic drugs in the United States that are scheduled substances? There are a bunch of clinical trials. That's super exciting. I'm working right now on the medical necessity case with one of the doctors who's involved in some of those clinical trials. And it's really neat. You know, there's, for some reason, clinicaltrials.gov has a whole bunch of psilocybin trials. They're doing some other trials with other hallucinogenic substances. And that is a way to try and figure this out. One of the things that's really important that we continue doing that as or not we, but the medical community, I would love to see them continue doing that because a lot of times what we have to deal with in the legal community is what is generally accepted in the scientific community. So we can define that community a little bit differently, but if we have a scientific community that says, hey, we don't really care what you feds think, you know, we're not gonna do the whole reefer madness approach, the medical community is going to say, this is good and this is helpful. It forces the courts to evolve. The courts are not typically a great engine of change. Sometimes they will codify a general sense and make everybody get on board. But courts tend to be pretty conservative, and we need other people to be the front runners on there. Is there any good news? Well, you know, the clinical trials, yes. I don't know what this psychedelic ballot initiative actually says. I haven't read it. It might be cool. But remember all this whole sort of complicated scenario. I tell you what, though, if enough people are smoking marijuana, as in Oregon, where there is, you know, sort of like full-blown reefer madness on every corner, the feds don't have the energy to deal with it. So that's probably a good thing. Risks and benefits as trailblazers. I just kind of wanted to put this thing from Wikipedia up here. I guess Timothy Leary was arrested. He was in prison he was in like 36 different prisons. So, oh God, can I have one more minute? Wrap it up. Okay, so things to think about. I love this. Paranoid is good. Tidy is good. Don't leave your stuff laying around. Your phone probably isn't tapped, but if you have a sloppy dealer, don't talk about shit on the phone. Email is scary. Texting is really fucking scary, okay? Camouflage is good. Try not to look like a crazy mushroom-eating, acid-dropping target for police to harass. You're less likely to get fucked up if you look more like this. And Dalton advice, stay the hell away from the mushrooms in Cape Disappointment Park in Washington. The rangers know they are there. They have binoculars, and they might just love to stalk people, nail them, and make the shit up. That didn't really happen. Conclusion, if you're a license holder and you feel like you're in a sketchy situation, get some good advice. Watch out for yourselves, be safe, and may the force be with you. Okay.
Thank you much. We're looking for questions. Yeah, come on down.
Hi, I'm just curious about some of the implications for somebody that is employed by someone that has a zero tolerance drug policy and they go abroad to do some sort of psychedelic.
So in a very general sense, and without specifically giving advice, in many places, unless you're part of a particular contract employee, employment is considered at will. Some states regulate drug testing in the employment context. It kind of, in some states, it depends on whether it's really relevant to the work. Generally speaking, you're not in a great situation if you've got an employer who's really tight on those things and they have good reasons for it.
Okay, next question.
Hi there. Just wanted to inquire if you have any knowledge of the American Indian religious beliefs and the use of peyote, and if that's, and I guess on a federal level, they said it's acceptable or not.
So yeah, when we go back to that, and this doesn't like to go backwards. I can't go back, sorry. If we go back to that RFRA map that I showed everybody, I think the RFRA map kind of tells us that it's confusing because there are some states that have embraced they have their own Religious Freedom Act, and they don't really mess around with people, and so they do consider that people have these freedoms. There's the federal RFRA, you're on an Indian reservation, and it's just the feds, and you qualify under the federal RFRA, then that's probably a thing, but the RFRA doesn't apply everywhere, and you have to know what your particular state says as far as that goes, as far as whether you're going to be, subject to state prosecution.
Okay, next question back here.
Yeah.
Oh, hi. As an anesthesiologist, I'm curious, do you know what kind of inertia is required in these clinical trials, or are there any historical references that you can speak to about what is involved in a DEA schedule shift?
So I haven't been involved in any of those processes advising clinicians, but what I would suggest is you can go to the clinicaltrials.gov, and you can do like a word search. Basically, you can come up with a bunch of clinical trials. It didn't take me a super long time to find people who were involved in clinical trials. And my guess is they'd be probably pretty generous in terms of helping give guidance as far as that goes. There may be lawyers who are specialized in guiding people through that, but my guess is and I don't know the answer, but my guess is it's probably more of a, administrative kind of who knows how to do this paper, like a grant writing thing. Although certainly there's more regulation involved when we're talking about clinical trials. And
Okay, over here.
Yeah.
Hi. So a couple years ago, I saw Rick Doblin speak and heard him discuss merciful use laws as far as accessibility for some of this work to be done. And I don't know much about them. I wonder if you could speak to that.
So I haven't really researched those kinds of laws. I know that Oregon was certainly a trailblazer. What I would say generally is, as far as merciful use, if we're talking about life-ending medications, that's a pretty heavy thing, and it certainly merits having a local consultation with a real expert in that area in the legal field. Merciful use in the context of, I don't know that there's, I think that's kind of, I would categorize it somewhere towards medical necessity if we're talking about using hallucinogens or something like that. That's going to be a real specific question for each state, and unfortunately I can't just kind of give a pat answer on that for my state. It's super complicated. In Washington, nobody's tried medical necessity with a hallucinogenic substance. As far as I can tell, I'm the first one. And I don't know how it's going to go, but it'll be a lot of fun, and maybe we'll do some cool things.
Okay, next up.
It seems like the Religious Freedom Restoration Act and all that sort of argument for this is asking for exceptions for these medicines, but the Schedule I says that the substances covered under it are all deemed medically not usable. Is there anything happening to get these medicines off of Schedule I?
Well, so remember when I was talking about the medical community and trying to evolve? Deemed medically not usable is something that Congress decided based on testimony and research. And so Congress basically said, oh, it's the consensus of all the doctors that we care about that these are medically not useful. But if we have a medical community that's really active in terms of really exploring new therapeutic approaches with these listed substances, and we can get a body of literature that's strong, you know, they may have to reschedule it, and that's a political process as well, trying to fight to have particular substances rescheduled so that they're not scheduled as Schedule I. You know, if we could get psilocybin, for example, off Schedule I and get it on Schedule II, get it on a different schedule, we may have, you know, a therapeutic revolution.
Moving into lightning round, please keep your questions very, very quick.
What can you tell us about statute of limitations as it applies to documentation of either uses or existences of formulations and compositions involving psychedelic substances?
So I'm not going to answer statutes of limitations questions because it's a jurisdiction-specific question. If somebody came into my office and said that, and asked me that question, I would do the research and I would tell you. But what I would have to do is look at the whole scenario. I would have to figure out all of the potential laws that I think might have been violated. And sometimes when I'm researching a statute of limitations, I may come up with, you know, here are 6 different statutes that may have been violated, and each of those statutes might have a different statute of limitations. So it's not an easy question to answer, but if you're concerned, certainly if you're concerned that you're under any kind of surveillance or that you are running a specific risk, my recommendation is go talk to a great criminal defense attorney in your jurisdiction who can answer those questions. It's well worth the money to sort of figure out, you know, what is my risk here and is there anything I can do about it?
This may be the last question, so keep it quick.
So we have had no major federal involvement for the recreational marijuana in our state. Do you think that would change for psilocybin or other substances that we were to push toward legalizing on a statewide level?
Well, I'm super hoping that I don't have to try to go to Canada forever. I don't really know how to answer that question. I think it's certainly a political question, and we're in times of really horrible political turmoil. And so I think it really is it's a really sort of dire question in terms of what is the federal landscape and funding going to look like. If you bankrupt the government, you know, you don't have a lot of resources to chase potheads. But on the other hand, if military and police sort of, you know, on the federal level, that's why it's a little scary for me. As an individual, because I'm a lawyer and, you know, we have this awful, the previous speaker was talking about that whole square problem.
Right.
We have this awful streak of sort of self-protection. I don't know.
Final question.
You had mentioned you were concerned with a friend of yours or a client that was working with CBD, and so since recently that GW Pharmaceuticals got approval for Epidelics and they moved it to Schedule 5, what are the implications or potential repercussions of a business working with a Schedule 5?
So again, that's one of those kind of jurisdiction-specific questions. I would certainly consult with an attorney on that. Look at Schedule 5. It's usually very complicated in terms of licensing requirements. So that's a great thing to consult with someone who is involved in federal regulations and able to give you that answer. I can't do it off the cuff.
Okay, thank you so much for an amazing and insightful presentation.